Well, a very good morning and welcome to Citizen Extra on this, the 4th day of September, the first Monday of the month. My name is Wahiga Mwaura. Now, this week, all eyes are on the Independent Electoral and Boundaries Commission, who are expected to issue guidelines on how the fresh presidential poll will be carried out. The pull and push between Jubilee and NASA is whether the same body that, according to the Supreme Court, bungles the presidential election can be trusted to conduct another election. The big question this morning, we are asking, can IEBC be trusted to oversee this election? We'll be reading out your views as we preview the next 50 days, or 58 days rather, and IEBC's dilemma in the course of this broadcast. Talk to us on 22422 and on our social media platforms at Citizen TV Kenya as well. Meanwhile, this past weekend, judges and magistrates challenged President Uhuru Kenyatta to stop his attacks on the judiciary, following the decision of the Supreme Court to annul his re-election last week. For more on this, we host representatives from the Law Society of Kenya, including its president, and Judges and Magistrates Association. Finally, are you an owner of a small or medium enterprise business facing challenges doing business in this political year? What has been your experience? Talk to us again on our different platforms, 22422 on Facebook and Twitter, as we discuss the challenges and opportunities of doing business in 2017 in Kenya, a political year, and we'll be talking about that during the third hour of this broadcast. Well, many thanks indeed for staying with us. We have our correspondents around the country. We'll be talking to them about various issues, including, of course, one of the big talking points of today, the IEBC. Can they be trusted to handle the election? And we'll be talking about that shortly. But for now, we want to talk about matters judiciary. I'm glad to have Isaac Okero, President of the Law Society of Kenya, joining us in studio today. Many thanks indeed for finding time to be here with us.
You're welcome.
Indeed. But before we get his views on the statement by the President, let's listen in to some of the statements that have been issued either for or against the judiciary over the weekend. Let's listen into one of those now.
To our friends who have yet to accept the outcome, we continue to appeal to them that we have extended our arm and a hand of peace and a hand of friendship, and for them to use whatever legal mechanisms that have been created by our wonderful Constitution to express their dissatisfaction.
President Uhuru Kenyatta, immediately after the IEBC had declared him as the winner of the August 8th poll, that was the statement he made, directing that to the opposition and telling them that if you have an issue with the election, go to the Supreme Court. We have structures in place. The Constitution has given you that option. Go to the Supreme Court, give your evidence there and let them decide on the way forward. But let's now listen to what the President had to say after Friday's judgment by the Supreme Court, the statements that he made, and of course compare with those that he had given even before that. Let's listen in now.
We disagree with the ruling that has been made today, but I respect it as much as I disagree with it. I respect it. I disagree with it because, as I have said, millions of Kenyans queued, made their choice, and 6 people have decided that they will go against the will of the people.
Well, I believe we have some other statements that the President made while, beginning the campaign period again, even as we build up to the polls that must be carried out before the 1st of November. When we get a chance to play those, we will play them as well. But Isaac, thanks once again for finding time to be here with us. I believe you've had time to listen to our different leaders talking, and I want to start by getting understanding from you, your take on what the President had to say about the judiciary this weekend. And of course, speaking on behalf of the LSK and as an individual as well.
The initial statements that were made by the President after the issue of the result from State House, I think, were very statesman-like. He expressed dissatisfaction with the decision, but then went on to say that he accepts it, respects it rather, that he respects it. And that, I think, was proper. That was proper. What came after, quite frankly, was just appalling, and not what we would expect by any stretch from an individual who occupies a position, an exalted position of chief executive of this country, a symbol of national unity, and the President of the Republic. And that is why we had to issue a statement to condemn the attacks. you know, it is quite one thing to criticize a judicial decision, and that's quite fair. But then, what has been happening has been far beyond criticism. I've seen response.
How will you describe what has been happening?
Well, you know, they are insults, threats. That's not criticism.
Okay.
And to describe it as healthy public criticism in a democratic discussion, I think that's the phrase that was used by the Presidential Strategic Communications Unit. It's beyond the pale.
Okay.
It really is unacceptable.
For those who are not able to, you know, watch your press conference or get your press statements, can you summarize what the LSK's view is on all this?
What the LSK's view is, first of all, that the institution of the judiciary and the Supreme Court specifically must be respected. They have discharged their function by hearing the petition and rendering a decision. All the judges have done so professionally and properly. The decision was a majority decision of 4 with 2 dissenting. That is a position that must be respected. It is quite proper for one to criticize it. Of course, we are waiting for the details of the decision to come to be issued by the court within the first 21 days.
That's right.
But to attack the judges, to name call them, to state that they should await what will happen to them after the election, that is really absolutely, it is not just undermining the institution of the judiciary, but it really is threatening the state, because the state is comprised of 3 arms of government, and each of those arms must be properly protected. Now, you know, there have been suggestions that, you know, similar comments or very strong comments have been made by members of the opposition against the judiciary.
In the run-up to the judgment.
Yes, but, you know, when comments come from individuals who occupy powerful constitutional offices and exercise constitutional powers, enjoy constitutional privileges, because the president is the one Kenyan who enjoys criminal and immunity from criminal and civil prosecution.
That's right.
So it is in the unchecked abuse of state power that the Law Society should speak out. Others who
might not enjoy such
who do not enjoy such are ordinary Kenyan citizens, as I am, as you and I are.
Yes.
Even though they may be public figures of great prominence with great political support, in legal terms, they are ordinary citizens who are as exposed as you and I are to the consequences of such utterances from institutions within the Republic that are in fact required to enforce the law. And
so because of the position that the President holds, there is a standard that is expected to uphold as well, and that statements like this by organizations such as yours, the LSK, feel should not come from an office such as his.
They should not, and in fact, it isn't just a standard, it is a constitutional obligation to uphold and protect the Constitution, and that is expressed within the Constitution as an obligation that is imposed upon the President.
Some feel that the threats are potential attack on democracy. Would you agree with them?
Absolutely. You know, the judiciary is the last bastion of the rule of law. And once we do not have a functioning judiciary, then we're faced with anarchy. That is the only option that is left. So it is the responsibility of all Kenyans, democratic Kenyans, to ensure that the judiciary is fully protected as an institution.
What did Friday's ruling do to the global perception of Kenya's judiciary? How was Kenya viewed before Friday? And because I'm sure you've been in touch with friends and legal colleagues from around the world, what are they saying now about our nation?
Do you know, I have been receiving, on behalf of citizens of Kenya, I have to say, and on behalf of my colleagues in the profession, by which, of course, I have to extend to our brothers and sisters on the bench, commendations and praise from all over the African continent. In my position, I've been
including those that may not have an independent judiciary.
Very many of them have been facing the same challenges. There is a president of a bar association in Southern Africa whose application to the Constitutional Court to have the association joined as amicus curiae failed in a presidential petition, and she was asking us, how has Kenya done it? You're showing Africa the way.
Speaking about being enjoined, because the LSK has to be enjoined as what? Amicus curiae during the petition. Now that the matter is over, we can talk a bit more about it. We were limited last week. When the LSK asked to be enjoined, what was your basis for that? And how do you feel you overall contributed to the case, the way in which it was had? What do you feel your contribution was as a Law Society of Kenya?
When the Council of the Law Society of Kenya decided to approach the court on an application to be joined as amicus, the basis of this was that in the discharge of our statutory mandate under the LSK Act, specifically Section 4G, which makes it one of our mandates to protect the public, we wanted to be in a position to have the LSK present in court in order to assist the court to arrive at a just decision. And this would require articulating such a position as would seek to establish the supremacy of the Constitution. I don't think that anybody can argue about that. There have been people who have been saying, well, that was a partisan position, but I can't see how arguing for the supremacy of the Constitution can be partisan.
Because the Constitution is for all, not for one side.
The Constitution is for everybody. Yes, exactly.
Do you wish you were given more time? Was it 20 minutes adequate?
Well,
in hindsight?
Let me tell you, our advocates, Steve Mwenesi and Samson Omwanza Mbati, were given 20 minutes, but they did brilliant. We were able to do what we needed to do, and I'm very proud of those two gentlemen, and I'm very proud for the Law Society of Kenya.
Okay. As someone who understands the legal framework in Kenya, would you say that the Supreme Court was under immense pressure to make a decision that would cleanse itself from past perceptions, especially in 2013, that they are very state-friendly? Do you think there was a lot of pressure for them to make a statement with their judgment?
I think certainly they were under tremendous pressure, but I think the pressure really came from the very limited time that there is constitutionally to determine a presidential petition. But otherwise, I was always confident, once the court had been reconstituted under Chief Justice David Maraga, that they would rise to the occasion and discharge their responsibility, leave the country proud of what they've done. I was always confident that they would do that.
Okay. As we revisit, of course, the weekend that's been, the attacks on the judiciary by some feeling that the president's words were too strong, and the Jubilee Party as well. What are the implications of what has been happening now? How could this play out, especially if the Jubilee Party continue hitting out at the judiciary?
It cannot be. It certainly is not well-meaning for the country, for the institution of the judiciary to be undermined in the way that it is being undermined. It is not good for the country at all.
So you see nothing good out of it?
Nothing good can come from that path.
Do you expect to see more statements from the LSK, from the judges and magistrates? Are you in consultation, maybe waiting to see what will happen and then deciding how you would react?
I don't think that we act in consultation as such, but the members of the Kenya Magistrate Judges Association and members of the Law Society of Kenya, we all spring from the same stock.
Okay.
all these individuals start off as members of the Law Society of Kenya.
That's right.
And as advocates of the High Court.
Okay.
And so our response in that regard will be very much similar. We all remember the professional oath that we take to protect the Constitution and to advance the rule of law without fear or favor. So the lot of advocates sometimes requires us to say things that are uncomfortable to some people, but in the defense of the Constitution and in the advancement of the rule of law, when it has to be said, it'll be said.
Okay.
And so if there is an occasion again where the institution of the judiciary or individual judges are being abused and threatened, criticizing is one thing, but if they're being abused and threatened, then we have to speak out, especially when this abuse and threats are coming from the occupants of high state office who enjoy particular privileges that leave the courts helpless to themselves take action to protect their dignity. Then we'll have to speak out.
And for the benefit of Kenyans, for you, if you're talking about the judgment by the Supreme Court and questioning it, that criticism is allowed, but the issue is when you begin to attack the individuals.
When you attack individuals or
make
the
up the Supreme Court,
and threaten it or them with reorganization, or try and box them into put them into ethnic boxes, that's not helpful at all, and that certainly is not criticism or democratic discussion.
I want to get your take on a quote that is attributed to the Chief Justice Maraga. It says, and I stow it, those who listen to me frequently know that I am stressing that we, as a judiciary, are not the third arm of government, but one of the three arms of government, with equal stature and grit as the other two. Do you think that came out clearly in how the Supreme Court petition was handled? I
think it did come out very clearly. And it's a tremendous message that has been sent out to the region, to the continent, and to the world. People will look up to Kenya, and Kenyans should hold their head high for it. Okay. Yeah. We can foresee busy days ahead on the political front. Right now, one of the biggest discussions is about who will handle the upcoming election. There are a lot of legalities in all of that, because a lot of what should happen is anchored in the Constitution, but where there are concerns by certain sides that, for example, the IBC might not be a fair player. Could we see the LSK offering more legal advice moving forward, offering advice? Because right now we see a battle between political solutions vis-a-vis legal solutions in a situation that Kenya has never ever been in before. What would you say about that? Yeah, this is new ground for everybody, and we as LSK we still certainly operate under our statutory mandate to assist on all matters concerning affairs of the law. How we can assist, of course, is a matter that will require some discussion and consultation, but it is a very delicate situation that we're in, given also that the President of the country now serves and exercises powers of his presidency subject to Article 134 of the Constitution of temporary incumbency, and that is a period. The period of temporary incumbency comes into force from the moment the first vote is cast in the presidential election until the moment that the elected president is sworn in. And during that period, there are certain constitutional limits to the exercise of presidential power, including a limit that prevents the president from exercising the power to appoint or dismiss public officers, which will include the officers of the IBC, the commissioners.
This is a question that I wasn't planning to ask you, but I guess now that we've gotten to this point, I know many Kenyans at home are asking, after 60 days, if we do not have an election, did the Constitution foresee a situation like that? Is there a line somewhere that could help answer that question of what next?
The short answer to that, I think at this time, would have to be no. That question was asked of me quite recently also. Okay. I think what we will have then is a full-blown constitutional crisis, which is certainly not a good place to be.
And which players would be expected to then weigh in on a constitutional crisis? Who should Kenyans look up to? Is it again, I don't know, maybe
that's a whole gray area, but it's an area that it's a place that we don't want to be.
That we don't want to be in.
Yeah.
Okay. And the bigger picture of the Supreme Court judgment that many are now wondering is, does this now show that the judiciary is ready to handle corruption? This has been an issue in Kenya because many say that when quote-unquote alleged corrupt individuals appear before the court, they are let free on many issues, they are able to threaten the judges and so forth. What the judges did on Friday, does that have implications for the lower courts moving forward? Can they now feel free to take on governors, senators, powerful individuals, and not have to worry about potential consequences or implications on their part?
I would expect and hope that this groundbreaking decision of the Supreme Court, being the apex court of the country, will certainly set the tone for all courts that operate under it, and embolden judges and magistrates to feel that they should be able to exercise judicial authority completely independently in the way that the judges of the Supreme Court have demonstrated that they can. So yes, I would hope we will see a full an effect that will trickle down to all the courts.
You're hoping that effect will trickle down to all the courts. In fact, let me give you a short break now. We cross over to Mombasa County, talk to Biki Dusa. We're talking about our institutions today, the judiciary. A bit later on, we'll be talking about the IBC. But we also want to hear from residents of Mombasa County, their take on the activities of the weekend and the independence of the IBC and the judiciary as well. And of course, their importance, even as we're getting ready for another election. Let's now cross over to Mombasa County. Biki Dusa, good morning. And let's get your take now from residents of Mombasa County.
Good morning, Wahiga. I'm coming to you live from Mombasa Island. And as you've said, I'll be speaking to some of residents of Mombasa concerning their reaction on the attack about the president, which has said on the judiciary. And I'm joined by residents who will be giving out their reaction. Na majina yako na utueleze maoni yako kuhusiana na hatua ya rais kuweza kuvamia idara ya mahakama.
Kwa majina kamili inaitwa Omar Ali Muhammad na mimi ni mkazi wa Mombasa. Kusema la kweli sikufurahia. Haswa sisi wakazi wa Mombasa na wakazi wa upwani kwa jumla hatukufurahia na maneno yaliyotolewa na rais wetu pamoja na makamu wake wa rais. Kwanza yataka Wakenya mkumbuke ya kwamba rais na makamu wake wa rais walituambia ya kwamba matokeo yoyote yatakayotolewa ni mahakama. Kama ni upande wa NASA wakubali, na kama ni upande wa Jubilee wakubali. Lakini jambo la kutushangaza ni ya kwamba baada ya mahakama kuamua kwa ukweli na kwa uwazi na makosa yaliyoonekana, wao hawakuridhika kabisa. Wakumbuke ya kwamba 2013 mahakama ilitoa uamuzi na kiongozi wetu Raila Amolo Odinga alikubali na akasema ya kwamba Kenya ni moja, tuendelee mbele na tumalize kila kitu.
Na tuambie majina yako na maoni yako kuhusiana na hii hatua ya viongozi kuvamia idara ya mahakama.
Kwa majina naitwa Bernard Okoth. Mimi ni mkazi wa Mombasa. Kila ambaye anasangaza rais wetu anajua kabisa yeye ni kiongozi wa Kenya wote. Na ile koti anajua kwa sababu gani ile koti iliwekwa pale pale. Hata baada ile koti kutoa verdict yake, tunashangaa kama wa Kenya, kama rais ambaye anajumuisha wa Kenya, unity ya wa Kenya wote, anatoka na kutusi koti na kusema wala ni wakora. Je, mtu kama mimi, mtu wa kawaida, nitasemaje nikishuka nikipeleka pale kotini? Tunashangaa na serikali yetu Kenya.
Na tunajiunga na mkazi mwingine. Na tutakuwa tunajiunga na mkazi mwingine. Atueleze majina yako na maoni yako kuhusiana na hii hatua ya viongozi kuvamia idara za mahakama.
Kwa majina naitwa Fadhili Ramadhan. Mimi ni mkazi wa Mombasa. Na kwa kweli tumeona uamuzi wa koti alioamua, waliamua kisasawa na tukaona rais amesema amekubaliana na uamuzi. Mwisho akabadilika tena akasema amekubaliana lakini kuwa hana mambo mengine na mengine huko. Na hatujaona maana yake ni nini. Tunataka wawe uwazi na aoneshe udemokrasia katika nchi ya Kenya. Kukubali ni kukubali, kama umeshindwa uende nyumbani. Aenda kapumzike rais wetu, tunaona naye pia ameshindwa. Asante.
Majina yako na tueleze maoni yako.
Kwa majina mimi naitwa Jolo Simbo. Mahakama imefanya kazi yake. Na vile imefanya kazi yake, sasa hii tuache Wakenya waamue. Kwa sababu tukisema tunaongea mambo mengi haitatusaidia kwa sasa. Maraga amefanya kazi yake na tuache Wakenya nao pia waamue. Lakini kitu mimi ningependa kusema, rais awache kumlaumu bwana Maraga. Kwa sababu Maraga ni judge mkuu na anajua sheria, ile kazi ambayo amefanya ni kazi yake. Na sasa tusiekane kidole cha lawama. Tuache watu warudi kwa fresh election na Wakenya waamue. Asante.
Jina langu ni John Agesa. Mimi mkaaji wa Mombasa, na mimi nashangaa sana bwana rais kusema ni wakora waliamua kesi. Because the same court 2013 iliamua yeye ni mshindi na alikubali paka akapiga makofi. Saa hii ameonekana hajashinda, tena anasema wakora. Kwa nini hatu kusema ni wakora 2013? Saa hii anasema ni wakora. Kwa hivyo uamuzi uko mbali na yeye ni wakora. Ikiwa imemfavor si wakora. Na tafadhali tunaomba rais urais ni symbol of unity. Tafadhali unite wa Kenya, tuende kwa kura tukiwa marafiki na tupige kura, na baada ya kura tuone nani ameshinda kwa haki na halali. Thank you so much.
As you've heard, Waiga, there are many people are actually concerned about the attack from the president on the Supreme Court, and especially the CJ David Maraga. Over to you, Wahiga, in studio Nairobi.
Well, thank you, Biki Dosa from Mombasa County, for helping us to sample the views of residents of Mombasa about the attacks on the judiciary. Let's now get more views from residents of Eldoret, Uasin Gishu County, where we join John Wanyama. John Wanyama, it's been quite an eventful weekend. On one hand, of course, the Supreme Court judgment on Friday. Thereafter, the President and the Jubilee Party attacking the judiciary. And also, we'll be talking about the IBC later on. But for now, Wanyama, we want to know from you what residents of Eldoret think about, of course, the independence of the judiciary and the comments by the President.
Good morning, Maura. And here in Eldoret, Uasin Gishu County, residents still they are not in a good mood after the announcement of the court last week on the issue of the two parties to go back to the election. And here, Maura, residents are not, they didn't receive this news very well. And on the other hand, as you remember, Uasin Gishu is a cosmopolitan region. There are a few who are very happy and they celebrated this, but the majority of Uasin Gishu County, they didn't like the decision, and they have said they have accepted the verdict, that they are moving on and they are ready to go back to the ballot. Without wasting time, Maura, let me talk to residents here just to tell us what are their views about the court and how the leaders have been attacking the court. There are those who have been praising the court. What are their views? If I can start with you, maoni yako ni yapi kuhusiana na wale ambao pengine wanashutumu koti, wanasema koti haikufanya vile? Maoni yako kama mkazi wa?
Mimi kwa majina naitwa David Wanjala. Maoni yangu kuhusu judgment yenye ilifanywa na attack yenye hasa imeelekezwa kwa majudges wenye walitoa judgment haifai hata kidogo. Mimi nalaani wale ambao wanaingilia mahakama na kusutumu Maraga kwa uamuzi huo. Mahakama is an independent body, ipewe nafasi yake ifanye haki. Na kwa ukweli sisi kama wananchi wanyonge Maraga amefanya tumerudisha imani katika mahakama, kwa sababu ninaamini ukienda mahakamani saizi utapata haki. Mahakama ya zamani imekuwa imetufanya tumekosa imani na mahakama, lakini kwa sasa tumerudisha imani kwa mahakama, na tunaomba majudges wakishafanya uamuzi wasiingiliwe, especially president na deputy. Hawa ndio watu wakubwa sana katika inji, hawa ndio mfano wetu. Wakiingilia mahakama, kila mtu ataingilia mahakama na tutakosa haki mahakamani, watu watakosa imani na mahakama. Lakini kwa sasa tunaunga mkono uamuzi ya Maraga na tumerudisha imani kwa mahakama kwa sababu ya Maraga.
Mimi binafsi niko na maoni tofauti, sababu kabla ya mahakama kutoa judgment yenye ilitoa, the first thing, the opposition that was led by the NASA leader, who is Raila Odinga, the petitioner, kwanza aliingilia mahakama kwa kuintimidate the judges. Walienda wanafanya maombi, wanatoa threats that they must redeem themselves. To me, I can see it was just but an intimidation to the judges. So serikali ama rais na deputy kuelekeza lawama kwa judges, to me it is good, because that was a political judgment. Maraga himself failed, sababu this is the second time Maraga is failing those who are less privileged. Sababu mara ya kwanza Maraga alirudisha judges ya ule askari mwenye aliwa mjumbe wa Inamui from murder case to manslaughter. That was not fair. To date, Maraga has questions that he must answer himself. So I would urge the president, a form tribunal wachunguze Maraga as an individual. He must stick to the constitution, because the constitution is the supreme law of the land. So if he is fair in the petition that was taken by the NASA to the Supreme Court, let him be fair across the board. Kuna wale judges wenye walisema wale dissent. Kwa nini wao hawakuruhusiwa within that duration of 21 days yenye Maraga alisema, pia na wao waseme maneno yao?
Kwa majina naitwa Daniel Chibororo, mkazi wa Eldoret. Kwa hakika kabisa sijaifurahia maneno ya mahakama. Vile mahakama walisema ya kwamba kesi watu waende uchaguzi mara ya pili. Lakini kama wakazi wa Eldoret hatukubaliane na, ingawa tunaheshimu. Kwa maneno ya kusema ati maneno watalete within 21 days. Kama hao walisema within 21 days, tulitaka tujue kwa nini walirulifu, na wangesema kama wale judges wengine wawili vile walisoma hawakuritika, wangesema hata maoni yao wenyewe. Kama vile wanasa ni kama wananasa walitisha, kwa sababu walisema wanataka kila judge aseme vile amefikiria, lakini vile wananchi tuliona wawili walisema maoni yao wenyewe. So tunataka wale waine waseme waliona nini mpaka wakarule against the president. Hatukubaliano nao kabisa. Kuhusu maneno ya uchaguzi, tunataka IEBC wafanye uchaguzi. Vile Maraka mwenyewe alisema IEBC wafanye uchaguzi. Hatutaki arbitrator akuja afanye kama UN.
We'll talk about that later, and if you can tell us your final.
Bas, kwa majina naitwa Simeon Mitei, mimi ni mkazi wa Eldoret, na maoni yangu ni moja. Maoni yangu ni hiyo tu ya kwamba Uhuru Kenyatta na Ruto are entitled to their own views. Wao under bill of rights katika sheria ya Kenya, kila mtu hako na haki kuongea vile anataka. Na kama wao kwa sababu ni viongozi wetu waliongea kuona ya kwamba Maraga alifanya makosa, mimi nasema ya kwamba mpaka saa hii Maraga alifanya makosa kubwa sana. Maana aliamua kesi kisiasa. Hakuamua kesi kwa sababu kuna haki. Hakufuata sheria. Kitu ya kwanza hapo hakufuata sheria. Na hii na maneno tena ya kusema wanagawana. Ati wengine ni 4, wengine ni 2. Kama ni wengine ni 4, wengine ni 2, sio ni siasa. Kwa hivyo Uhuru Kenyatta na Ruto wako na haki kumwambia Maraga you did wrong. And tunasema that's wrong. Maraga ajiuzulu. Hatutaki Maraga tena.
Thank you very much, Mwaura, and because of time we will wish to take more views from residents here, but as you can hear clearly, the residents here, most of them are really disappointed, and they are saying that whatever the deputy president and the president are saying about the judiciary, it's okay. Those are their views, Mwaura, and we are still following up on these issues, and we'll come back later with the IEBC issue. From Uasin Gishu, Mwaura, back to your studio.
Well, thank you so much, John Wanyama, for that update from Uasin Gishu County. Earlier on, we were speaking to Biki Dusa in Mombasa County. Tough time to be the Chief Justice, I must say. Praised in some quarters, vilified in others. Let's get some reactions now to some of those statements. Let me introduce my expanded panel in studio. To my far right, Joy Mdibo, advocate. Welcome to the program. Dansan Omari, many thanks indeed. Funny thing to be here with us. Welcome to the broadcast as well.
Thanks a lot.
Boniface Akusala, it's been a busy weekend for you as well, I know. Welcome to the broadcast as well. And we carry on with Isaac Okero, the President of the Law Society of Kenya. Joy, I'll start with you. Your reaction, you've seen what some of the comments from Mombasa County, others from Uasin Gishu. You've been reading what's happening online. You've been following the conversation. Your take on the attacks on the judiciary?
Off the bat, let me start by saying, as far as I'm concerned, that's not really an attack on the judiciary, an insult.
Oh, it's an insult.
On the people who sat as the court to determine this matter. And that insult is inappropriate. Why am I saying it's not an attack? It is impossible to attack the judiciary unless you've got a tool that would actually hurt them. So in this case, these judges have got security of tenure, which they already know. They have done their work and they've made their decision.
So a verbal attack is not an attack.
You know, if even in law, if you're accusing somebody of attacking someone, there has to be that reasonable. There has to be an encounter. I can't be attacking you over there. There has to be the point of contact. But because as far as I'm concerned, the president was 1, obviously upset. 2, obviously in a state of agitation, and then he took the opportunity very soon after the ruling to make a knee-jerk reaction. Was he correct in doing so? Absolutely not. It is inappropriate what he did. As somebody correctly said, he's a symbol of national unity. This is the person who's supposed to be galvanizing the nation. He started with a very stately statement in State House, then went on the road, and within an hour was mouthing off. So that was very inappropriate. But would I term it as an attack? If I was the judges, would I be quaking in my boots? No, I would be just sitting there pretty, writing my final judgment because somebody is waiting for the reasoned ruling. Because if you understand how the judiciary works, especially for the judges, the reason why they have security of tenure is so that this the political class cannot just willy-nilly wake up one morning and decide, by the way, you guys are going home. Even there was somebody who was saying let's form a tribunal for what adventure. And if you go across the board, it doesn't matter whether in Jubilee or whether you're in NASA, ask any advocate or any member of the bench, this is ridiculous. And quite frankly, if I was the president, I would find a way of backtracking and saying, you know what, I was just annoyed, it was just politics, no hard feelings, let's move on.
Danstan, would you backtrack if you were in the president's shoes?
Well, when you look at the comments of the president, you look at the comments still that were being said by my deputy president at Githurai yesterday, naming and profiling judges. You look at the clips, the strongholds of the president. To them, everything is right. And I understand...
Sorry, just say again, to them?
To them, what is going on is perfect and right. The president is doing his thing very well. The deputy is doing very well. The Duales who are profiling Justice Odunga is doing that very well. The reason is so simple that we need to understand.
Are you saying you're comfortable?
I'm saying the people who believe in the president's version find it totally very well. I need to look deeper. Why will a certain section of a community believe what everybody thinks is totally unacceptable? It is not in any standard worldwide acceptable. Why will a certain sector of our country justify that which everybody thinks is a serious leprosy? The answer is simple. The elections in this nation have been following the doctrine of the common law, where the common law doctrine from Britain was based on a monarch. It was based on God-appointed leadership. So that once somebody has been given that mantle, whether it was an illegality, whether it is what, the court's role is to confirm that person. In 2010, Kenyans made a constitution and ran away from that question of the court being a rubber stamp. Very few Kenyans read that. You know, we have the problem of Raila Odinga and Kibaki reading. Had they read, they could have known that now what will be used to determine the election is the legality, the evidence, not the question that he has been declared. So when you see the president mad, you will tell people that when the president, when the church, when the business community, when everybody, the world over, was telling Raila, go to court, they knew that the court is that rubber stamp. They never knew that the court is going to decide based on the new constitution. So the reaction we see is the affirmation that the sovereignty of the people moved away from that metaphysics, from that doctrine that you must confirm, to the question of evidence. And therefore, in our own view, the president got himself off. Reliably, people were continuing to prepare for the swearing in, because people have known the traditions, the rituals of 2013. People knew, we know already the decision. When you look at the councils, my colleagues, the president is here, with due respect, you saw the president's lawyers, you saw the IBC lawyers. They were not worried about the case, because to them, that Victorian doctrine will still uphold the day. So when the president was a formality, to them it was a formality. Until it is a wake-up call now that it is no longer business as usual. And that is what has found the president off guard, the deputy off guard, his stronghold off guard. But I advise them that that is the law for now. It will never change unless a referendum. Threats to the judges. Article 168 completely insulates the judiciary from any political activity. Parliament is not involved in anything. So if the president thinks he's going to use parliament, the attorney general and other senior lawyers should advise him that to read Article 168 properly. They have no say. And Wahiga, is this the first time a law was passed to amend the JSC Act so that the president is given 3 names to appoint? What happened? The courts declared that unconstitutional. So my position is that is a wake-up call to every Kenyan. Don't think you are entitled to any right. You must justify that right.
Boniface Akusala, I understand treading on slightly dangerous ground there. I want to get your take, nevertheless, on the activities of this weekend.
I'll start by, first of all, quoting James Madison in Federalist paper number 51, when he said, if men were angels, we would not need a government. And right now, the government expresses the will of the people. And the will of the people is founded in Article 1. And just give me a chance to read Article 1 for the benefit of the people. This is what 1.3 says. First of all, 1, all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this constitution. And what does this constitution say in Article 1.3? That sovereign power under this constitution is delegated to the following state organs, which shall perform their functions again in accordance with this constitution. And the 3 state organs that have been outlined in Article 1.3 are 1, Parliament and the legislative assemblies of county governments. Number 2, the national executive and the executive structures in the county governments. And 3, the judiciary and independent tribunals. Therefore, if one organ of state decides to usurp the role of the judiciary and perhaps come up with a predetermination of the case brought to it, and that is the mistake that the Jubilee enthusiasts have been doing, that they had a predetermined outcome
in mind, and when
it did not go that way, they are now chastising the judiciary. It is a very dangerous trend, because all that the judiciary needs to do is to apply the law. Bring us pleadings, bring us the law. We shall do an analysis of this and give a determination. Now, I will perhaps refer to a conversation that was in June 2017, where the president was referring to the opposition perhaps for not being very truthful to the judicial processes. Number 1, that when a decision is in your favor, you would agree with it. When it's out of your favor,
and you endorse that institution as independent, etc.
And interestingly, at the same time, the president and the deputy president are demonizing 4 judges and applauding 2 judges out of the 6. Curiously, therefore, it feels that there is a lot of dishonesty. I'm trying to be to apply euphemism as much as possible. There is a lot of dishonesty and hypocrisy. That
someone calls it doublespeak.
Yes, that is doublespeak in the superlative. Now, the constitution needed an interpretation. An interpretation in accordance with Article 259 that is generous and purposive, that is allowing the constitution to speak on its own. Article 140 spoke, and it gives the judges the chance or the option of nullifying an election. If the constitution did not provide for this, then perhaps the executive presently would have
a point, yes, grounds.
But there are no grounds if an attack on the judiciary right now is an attack on the constitution.
Let me stop you there, because I want us to look at something else. I want us to play 2 clips. The first is by NASA leader Raila Odinga before the judgment, his take on the Supreme Court, and the other is by President Uhuru Kenyatta this weekend, also regarding the Supreme Court. And my question to my panelists after that would be, is the judiciary independent and fair when it's in your favor? And does it have issues? Is it not independent? Is it not fair when it doesn't rule in your favor? Let's listen to those 2 statements.
The Supreme Court is made up of 7 judges. The discretion of 7 individuals, however wise, can neither represent nor substitute the voice of 15 million people. 7 individuals can be intimidated, they can be compromised, and they can make genuine mistakes. Kenyans are still trying to understand what exactly happened in the Supreme Court of 2013, when the decision about their votes was delivered in minutes and a paragraph. Institutionalizing the determination of elections by courts is a deliberate, cynical ploy to lend a cloak of legal respectability to fraud, subversion of democracy, and abuse of the court process.
Na tumesema amani. Lakini wajue hawa watu watano wa sita, kwa sababu Wakenya bado wataamua, watugojee baada ya uamuzi wa wananchi. Tuko na hawa hapa kwa hapa. Tuko na wao hapa kwa hapa.
Isaac, I'll start with you. You've heard you're president of these other panelists who are here with me in studio. I hope that they've done you proud by some of their opening statements. But I'll give you a chance to talk about that later. Double speak by both sides of the political divide. Would that be a fair description of what we were watching, or are the circumstances different? And can we say that no, we can't look at both on the same platform because the circumstances are different? How would you describe what we've just seen?
I think the circumstances are different in many material respects. First of all, one statement from Raila Odinga, the NASA leader, expressed, I think, and in the context in which it was made, the dissatisfaction with a situation in which elections will always end up in court, to be determined by the judges of the Supreme Court. That, he said, is not a desirable way in which the electoral process and the expression of the democratic will of Kenyans should be exercised. That's in contrast to a position taken by the president, who, unlike Raila Odinga, is the symbol of national unity, has a constitutional obligation to protect and uphold the Constitution, and also enjoys immunity from civil and criminal proceedings.
For discussion,
all of that, yes, I'm coming to that.
Okay.
Here he is expressing a position after a decision has been made, disparaging the judges in their personal capacity and calling them names. I can't see where the similarity is.
So, for discussion's sake, if it was Raila who was seated at State House and Uhuru who was the opposition leader, would you then say that in this case now we would, the LSK and other bodies would turn their guns on Raila because he holds the seat of presidency for discussion's sake, but it's okay for an opposition leader because as much as they're respected, nevertheless they do not have the same privileges and rights, etc., as a president would?
You know, and I'm glad you've asked me that question, because as Boniface just said as he began his statement, the delegation of the will of the people under Article 1.3 reposes in the office and person of the president. That makes all the difference, you know. The fact that in that capacity, enjoying all those immense powers and privileges, he cannot be seen then to be using that position to undermine one of the institutions that have been set up by the Constitution, which must be protected by him under a constitutional obligation. Now, it doesn't mean to say that when Raila said it, it is okay, but for whatever immense public stature he enjoys, he is an ordinary citizen. He can be summoned by the courts and be subjected to contempt proceedings. The president can't. And that's a world of a difference.
And so, for example's sake,
whoever is in the position of the presidency who acts in excess of state powers will attract the criticism of the Law Society of Kenya. Even if it is my friend here, President Boniface Akusala. Whoever it is, that's the position of the
And for discussion's sake, we could say that, using an example of the panel that we have here in studio, the statements that you make might be taken differently from the statements by Danstan, for example, because of the position that you hold in the LSK as the president, and thus you would be expected to measure your words more compared to, I'm using Danstan as an example, nothing personal, Danstan, because of the power and privilege of your position.
That is absolutely true, and I would hope, and I'm certainly subject to what my colleagues who are members of the Law Society would think. I have made every effort to be as measured and as consultative as I can, and as fair as I can in the statements that are issued.
Well, you've been wanting to come into this discussion. Double speak by politicians.
It is double speak, and I beg to respectfully disagree with my president here. The president of the Law Society.
With your
it is not for the stature that of politicians, especially the stature of Honorable Raila and Honorable Uhuru. in our society is almost at par. So if they're speaking, they have
Some would
millions.
disagree that,
I mean,
that the president, by virtue of his office,
somebody
is citizen number one.
Somebody like Honorable Raila Odinga, the people who, even with this election, whatever the outcome was, there are very many people who believe in him and who listen to him and who take what he says as something that they will also co-sign. So when they talk and they say those 7 people, these 7 people, they're actually doing the same thing. They're talking to their populace. My difference now is that I don't take those statements as being, let's say, an attack on the judiciary per se. I take it as being an insult to the judiciary. Why? It's not being made with the purpose of trying to change the mind of the court. It's being made in a political context. They're trying to speak to their people, trying to agitate. You saw them, they're already on the campaign trail. For them, it's already at time. We respect the decision, we're going to comply with the decision, but tell you what, let's show them again.
So the judges shouldn't necessarily be worried about the statement. It's not for them,
and that is
it's
why
for the
I
masses.
said, where the judges are, I do not think they're quaking in their boots. They're carrying on writing their judgments. It's not something that's having them think, oh no, am I going to be out of work tomorrow? No, they know very well that where they're sitting, they're very secure. What they did was well within the law. The decision that they made is well grounded and founded, and I'm sure once the ruling comes out, the detailed ruling comes out, we will see their reasoning. And I doubt there are very many lawyers who will totally disagree with the reasoning once it comes out. Because look at the judges we're talking about. Judge Maraga, Judge Lena, these are people of...
tried and tested.
And they have done extremely well ever since they came into the judiciary. Most of them have had a very stellar career in the judiciary. So even for my colleagues sitting here, if they bring the judgment tomorrow, it doesn't matter the side of the divide. We'll be reading it and thinking, hey, this is excellent jurisprudence. Now we have got something to lean on. Even the floodgates of the election petitions, people are waiting for them so that we can also go file our matters. So in my opinion, if we put this in context, we'll realize we're making a mountain out of a molehill. I doubt that judges are now thinking, oh, are we in trouble because our jobs, or because we made this ruling?
It's probably not a big deal.
So
we should have wound up this discussion 30 minutes ago.
Which is why I was saying,
your president wants to come in
if you look
as
at
well.
If you look at it as political statements, insults, at the end of the day, what does it distill to? Absolutely nothing.
Isaac, come in briefly before I go to Dunstan.
I think it's important that I have to agree with Joy that I don't imagine that any of the judges are in fear of their jobs wherever they are. But we must remember the judges are fully aware of the status and purpose of the judiciary as an institution. They have certainly even before, since Justice Maraga's predecessor, Justice Maraga himself, they have invested tremendous time and resources in building public confidence in the judiciary, because it is key. It is key that the judiciary enjoys public confidence. We have seen the worst instance of what happens when there is no public confidence in the judiciary. At a political level, we saw what happened in 2007, 2008, and that was as a direct consequence of a lack of confidence in the judiciary. Now, this will filter down to the very basic Kenyan mwananchi who will not go to court because he doesn't trust the judiciary when he has a dispute with his neighbor. He'll take out a panga. That's the anarchy that we want to prevent. And that is why I can be absolutely confident that members of the judiciary will be as alarmed as the rest of Kenyans are when they see these insults being thrown at them, because what it does is, it doesn't threaten them personally, but it erodes the public confidence that the judiciary enjoys, and that is what is dangerous for the state.
Okay. Dunstan, briefly.
My take is quite different. Both the political players, Raila Odinga leading the pack, President Uhuru Kenyatta leading the pack, have failed the test of respecting the judiciary on equal measure.
Okay.
If you remember what was happening during the Al-Gurea case at the Court of Appeal, not the Al-Gurea case, the question of whether the polling center, the polling station is going to be the final destination and determinant. Raila Odinga and his group really put a lot of pressure on the judiciary. They made very unsavory comments against the judiciary. That time, it was right for the NASA brigade to celebrate. The Jubilee guys didn't comment about it. It went to Baringo. The president and the deputy, that is Jubilee Brigade, give another attack. NASA came up shouting that the president is messy. We are seeing, before the filing of this case at the Supreme Court, Raila Odinga gave a very intimidating attack.
Together with other NASA leaders.
The NASA leaders, a very intimidating attack that we are giving you this thing to redeem yourself. That is a serious attack and intimidation. We've seen the president and his group after the decision doing the same. So, Wahiga, my position is this. The political class thinks that this nation is owned by them. There are not more than 10,000 people. This country is bigger than the politicians. The politicians call the legislature and the government call the executive, leave the bureaucracy, is temporal. Always 5 years. They must seek my consent to give their will over me. Okay. That is Montesquieu himself saying that every 5 years they come to me, they come to Wahiga to ask for that, because we are the sovereign. At one, my good friend has read it. It is that. And only through my consent, or that consent of my people in West Mugrango, can a government be formed. This consent is in this book called the Constitution, which defines who is sovereign. And in Article 2, it talks that Article 2, at clause 3 says the validity or legality of this constitution is not subject to challenge by or before any court or other state organ. You can never challenge this. It speaks by itself, whether through a court of law, whether you go anywhere. So this is what saves us. Also, it moves on Article 3 and defines how governments are created. In Article 3 it says an attempt to establish a government otherwise than complies with this constitution is unlawful. Therefore, if you want to form a government in this nation, you go to court.
You follow what's in the constitution.
It tells us that it created the constitutional court called the Supreme Court.
That's right.
You go there. If the Supreme Court decides the way it decided in 2013, Uhuru Muigai Kenyatta becomes the president.
If it decides
like now, it has decided that go to another election. That is the position of the law.
I'll have to stop you there because you're usurping Councillor Kusala's time. So allow me to bring him in as well. Go ahead.
First of all, bringing these two statements in context. Number one, I agree with what my learned senior, Mr. Okero, says, that the position of Raila and the position of President Uhuru, constitutionally speaking, are not on the same platform.
Are not at par.
Uhuru is head and shoulder above Raila in view of the office that he is holding. Now, to whom much is given, much is expected. A lot of responsibility is required from the president as opposed to Mr. Raila Odinga, who is not recognized by the constitution in any way. Initially, he would have been leader of opposition. He is not. So, therefore, Uhuru owes allegiance to the constitution. He has an obligation of not undermining any state organ that has been created by the constitution, which also creates his own position. Now, basing on that, whatever comes from his mouth needs to be well measured and sieved, because whatever he says should be in agreement with the constitution. It is now the voice of the Kenyans. Being the symbol of national unity is not just an officer skeleton. Whatever he says, the international community understands that that is what Kenya is saying. Yes. Now, my learned friend Mr. Omari has quoted the issue of the pressure that had been given to the judiciary. The judiciary to redeem itself from the ghosts of 2013. The 2013 decision, with all due respect, fell short of the quality that was demanded by even ourselves, practitioners of law. Therefore, it was time that the judiciary came up with a decision that if you disagree with it or you agree with it, you are contented that justice has been served. There were many issues that were running behind the scenes in 2013, which we were praying so hard they do not be repeated. And that is all that we are saying, that the judiciary, can you redeem yourself? Right now we are saying IEBC, can you redeem yourselves? It is not any form of pressure. It is a reminder that we feel that the law was not followed properly. Can it now be followed well?
So the Supreme Court followed the law properly, but many are now asking IEBC,
yes,
can you follow?
IEBC, are you able to redeem yourself? Can you now follow the law properly as is in the Constitution and the electoral laws?
I'm going to have to stop you there because time is far much gone. That's how we wrap up this part of the broadcast. This being a topic that we can sustain for maybe 3 hours, but thank you so much to all my guests who found time to be here with us to discuss this. We'll still dabble a bit more in matters judiciary on the other side of this break, but for now I want to say thank you so much to Isaac Okero, President of the LSK, and Boniface Akusala, Advocate. Joy and Dunstan, I might retain you for the next hour, but we take a break right now. But before that, let's cross over to Chiromo Mortuary, where Hassan Mugambi is on standby. As you know, terrible tragedy that happened this weekend at the Moi Girls High School in Nairobi. 8 girls believed to have lost their lives, or the fact that we have is that 8 girls lost their lives in that particular tragedy. A post-mortem expected at the Chiromo Mortuary. Let's now get more details from Hassan Mugambi. Hassan, what can you tell us as of now?
Well, thank you very much, Wahiga. As of now, the Chiromo Mortuary has already opened its gate to the parents of those that lost their lives in the tragic incident at Moi Girls High School in Nairobi, to just come so that they can surrender their DNA samples for proper identification of the bodies that are being preserved here. We're expecting that the chief government chemist will be here, as well as the chief government pathologist, to undertake that particular exercise, as well as handing now the bodies to the respective parents who will be showing up here for burial purposes. But yesterday we saw 46 students out of the 51 that were admitted in the various hospitals, that is the Nairobi Women's Hospital as well as the Kenyatta National Hospital, being discharged. 46 of them were discharged, and then we have 3 more who will be discharged today, but then again we have 2 who sustained very, very critical burns, who will be continuing with their treatment at the Kenyatta National Hospital burn section, where they will undergo plastic surgery after that. The parents, teachers, the board of the Moi Girls High School yesterday also called on the detectives probing the matter to come up with a strategy to speedy investigate the cause of the fire for closure purposes, so that they can take appropriate action should it be a case of an arson attack or something like that. But then again, speaking to the detectives, they said that they have already spoken to close to 50 students who just were telling them what exactly transpired before the incident took place that fateful night of that fateful Friday night, rather, because it is something that really took the country by grief, so to speak. So we're waiting for the detectives, the homicide detectives probing the whole incident, to just tell us what exactly transpired. The Ministry of Education, remember, Fred Matiang'i, also ordered the school to be closed for 2 weeks so that the investigations can continue, and as well as just to get the students away from that particular scene of crime as they continue with their psychological counseling, to just avoid the kind of traumatic experience that they had in that particular incident, Wahiga.
Well, thank you so much, Hassan Mugambi, for that update, and once again our condolences to the family and friends of those who lost their lives, and of course those who are affected by this, the whole Moi Girls community. Our condolences and just our prayers with them as well. Well, we take a break now, this being the end of the first hour of Citizen Extra. We'll be right back to talk matters IBC. On the other side of this break, you're watching Citizen Extra live on Citizen TV.